And everybody, we just got this case. We're told as the decisions have continued to be released from the Supreme Court, this one is now officially released. Of course, our team is going to read into the decision to compare it with the decision that had been put out on the docket yesterday, make sure that we are getting everything correct as we move forward in our conversation around this. But I want to ask you, Neil, as we let our team look more closely at this decision, what are you looking at specifically here? And can you also weigh in on what we heard, Anthony and Lisa discussing about the Supreme Court knowing exactly what it's doing and the idea that they may have some political calculus here to not give a definitive answer on this particular case?
Yeah, so looking at the decision that was just released just in the last half minute, it does look like the decision that we saw briefly on the website from Bloomberg. So I don't notice any discernible differences. Here's why that's so important. It's basically the 2-year anniversary of the Supreme Court issuing the Dobbs decision in overturning Roe versus Wade, which was one of the most massive changes to the law in our lifetimes. And if you were to just look at the headlines this year of the Supreme Court's 2 abortion decisions, you'd think, hey, they're trimming things back. In the mifepristone case, they unanimously said that mifepristone could remain because there was no legal standing, no ability to challenge it on the part of the private doctors that brought that case. And similarly here, if you looked at the decision, one way of reading it is to say, oh, things are good and now safe for women in emergency situations like Idaho. And both of those are overreadings of what the court did this year. In one case, mifepristone, it was technical, it was on standing. They, in fact, opened the door for other people to file the same challenges, the same, I think, bogus challenges in my mind to mifepristone that were filed. And here, as has been pointed out, this is just a temporary delay in this kind of lawsuit about the meaning of the federal law. This isn't settling it or giving the last word, and certainly not providing reproductive justice for Americans. And so I think, good, these are welcome, modest victories, but that's all they are.
And I have been told that our producers who are looking at this opinion say it appears to be identical to the decisions that were posted yesterday on the court's website and then taken down. Lisa, I know you're digging into it right now, but just remind our viewers again what this decision means when it comes to this Idaho abortion law and this federal law, this state versus federal conflict, it appears.
Yeah, well, for right now, it's a temporary reprieve for women in Idaho and their physicians from the very strict statute in Idaho that prevents doctors from providing abortion unless necessary to prevent a woman's death. That having been said, I think Justice Jackson's concurrence in part and dissent in part really spells out the reality. It's not permanent. It is a delay. It is a temporary reprieve, and that's all it is, because one of 2 things can happen in the future. Either, as many already laid out, if former President Trump were to win election again, we have signals that the federal government would walk away from its challenge to Idaho's statute, that it would no longer continue this litigation. Because remember, this litigation was brought by the United States saying our law is supreme to Idaho's law. You need to comply with the federal statute governing emergency treatment of women and stabilize their condition in your emergency rooms, Idaho. So in a Trump administration, this case may not continue. The other problem is this case is going to be returned to the lower courts, and it's going to go through the conventional appellate process. And as Justice Jackson lays out, whether that means a series of months or years, this case will percolate back up to the Supreme Court, either from Idaho or one of the 6 other states that Solicitor General mentioned have very similar statutes. One way or another, the dispute between the federal government as the defender of EMTALA on one hand, and these very, very red states trying to forbid abortion in virtually any and all circumstances is going to come back before the court. It will live to see another day. This is just kicking the can down the road. But for now, it is a reprieve for women in Idaho and their doctors.
Big picture, This was a political decision by a court that is supposed to be above politics. And the fact remains that there is a sustained assault on women's reproductive rights in this country. Right now, Anna, 1 in 3 women of reproductive age live in a state with an abortion ban. 1 out of 3. And if this court had its way over the next year or two, those rights across the country are in danger for many more women than we are seeing in Idaho and in those states that are subject to those bans.
Let's go to Yamiche Alcindor, because you're reading through this opinion. Yamiche, bring us some of the key quotes. What stands out to you?
Well, what really stands out to me is Ketanji Brown Jackson, and we often ask what the split is here, and it's not a clean split because Ketanji Brown Jackson both concurred with the idea that this needed to be stayed and that this law from Idaho did not trump federal law. In other words, that women should still be able to receive emergency abortions in the state. But she also wrote a dissenting opinion here, and I'm reading part of what was put out yesterday. From our understanding, it's pretty much nearly identical to what is out now. And when you read it, you can hear the frustration in her writing, because she says that really this court should go further here and that they're not doing enough to actually say in fact that this law from Idaho, that it should completely be out of the door, and that the federal law should trump all state laws that have near total bans and that would stop someone from getting an emergency abortion. So I want to just read part of what she wrote. She said, "Today's decision is not a victory for pregnant patients in Idaho. It is a delay. While this court dawdles and the court waits, pregnant people experiencing emergency medical conditions remain in a precarious position as their doctors are kept in the dark about what the law requires. This court had a chance to bring clarity and certainty to this tragic situation, and we have squandered it." She said, and she goes on to say, and for as long as we refuse to declare that what the law requires, pregnant patients in Idaho, in Texas, and elsewhere will be paying the price. She goes on to say, and I think it's really important there are a number of questions she writes. She says, "How long must pregnant patients wait for an answer until we confront the pending petition that the government filed with us under this court?" She also said, "Maybe we will keep punting this issue altogether, allowing chaos to reign," she says, whenever a lower court enables states to flagrantly undercut federal law. So really in this decision, you could just hear Ketanji Brown Jackson's frustration, saying that yes, this law should not go forward and that this law should not trump federal law, but she's also just saying this court should be doing more. This court should be saying other states like Texas and other states that have these sort of near total bans on abortion that would stop a woman from getting an abortion that she needed if it dealt with her health, not her life, that those things should have really been made clear in this court today. I also want to say that in talking to reproductive rights groups all yesterday and today, and also some Democrats on messaging ahead of the debate, they're echoing the language of Ketanji Brown Jackson, saying that this is really a temporary win, but that women in Idaho, while they can right now get emergency abortions, it's not clear that that will be the case for years to come. So it's, I think, a really important point that she's making here when you look at it from the side that she's coming from it for. And I think we should remind people here the difference between life and health, she writes in her dissent and in part of her dissent here, is that women could go into emergency rooms and not be on death's door, but could end up having to have hysterectomies, could end up having to lose their future fertility. So Ketanji Brown Jackson is saying this is a very scary situation, and this court should be doing more to really give clarity to doctors and the women facing these issues.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.